Record to the cloud. Okay, now we're recording. I'm Aaron Schmidt, and I'm a Vice President in Labor and Employment at the American Arbitration Association. This is Workplace Challenges, Drugs, Sex, and Rock and Roll. I think we have the coolest name at the conference. I'd like to introduce our three speakers today. Barbara Diamond is a labor, employment, and civil rights lawyer with over 30 years of experience representing labor organizations in Portland. In July, she'll be closing her law practice and hanging out her shingle as a neutral labor arbitrator and mediator. Catherine Walters is a partner at Bybel, Rutledge in Pennsylvania, where she provides exclusive management-side labor and employment services for employers of all sizes. And David Stiteler is a full-time labor and employment arbitrator. David's on arbitration panels administered by the American Arbitration Association and FMCS. We recorded the presentation part of our program today to avoid any technical problems. So I'm going to go ahead and share my screen and play our presentation, and then at the end we'll take questions live. So we will get started.
Hello, my name is Barbara Diamond. I use she, her pronouns, and I am reporting to you from Portland, Oregon today. I will be speaking today about my favorite topic, drugs, sex, and rock and roll. There's been no topic I've ever presented on that has given people as much fun as this topic. So hopefully we will share some new information and get folks thinking about where this topic leads in arbitration. There's a general rule that applies to all off-duty misconduct that the employer cannot discipline an employee for off-duty conduct unless the employer is able to establish some sort of workplace nexus between the conduct and the job. And nexus is not viewed lightly by arbitrators in practice. The nexus must be proven by clear and objective evidence that connects the conduct to the employee's ability or inability to do the job. The most common ways that I've seen that the employer proves nexus is through one of three different ways. One is that the employer can prove by objective evidence that the employee's off-duty conduct has created harm to the employee's business interests. That's something that can often be proven by social media evidence or by direct testimony, but it won't be implied. In other words, if the employer argues that particular off-duty conduct could, might, or has the potential for interfering with the business, often arbitrators will say that's not enough. You have to prove that there's actual objective harm. The second category of cases in which employers are able to establish the appropriate nexus has to do with employee fitness. Obviously, if you have an employee where it's found out that that employee is addicted to heroin or some other kind of drug, it could affect the employee's ability to work. And again, when there are role model responsibilities, often teachers, police officers, firefighters, their off-duty conduct will be scrutinized with a much more significant lens when it comes to the question of fitness for work. There's also the test of whether employees will refuse to work with a particular grievant in an arbitration. That will often be a criterion that will help the employer show that the employee's off-duty conduct has had an impact in the workplace, a significant enough negative impact that disciplining the employee is the appropriate action to take. So those are the sorts of evidence that arbitrators traditionally look for in off-duty misconduct cases. Now, what are the types of harms that can occur to an employer which arbitrators may consider to be sufficient to satisfy the nexus test? Certainly, we talked about notoriety, and I know that later on we're going to have a discussion of social media. We know that social media is a way that very small actions done in privacy can become quite infamous. Certainly, any employee who disparages their employer on social media, and particularly in private sector cases, again, especially if there's evidence that the disparagement has actually harmed the employer's business, caused complaints to be filed with the employer, that's a type of objective evidence that an arbitrator will look for. The same thing with a provable loss or disruption to a business. The case that I've enjoyed handling that I found most interesting in my career with respect to off-duty misconduct was a teacher who was a member of the man-boy love group, but was not found charged or found guilty of committing any type of inappropriate action with minors. He was just a member of an organization that sought to change the age of consent laws throughout this country and is not a criminal organization. When he was terminated for belonging in that organization, there were questions of whether there was a sufficient nexus, as the fact is that there was no showing of wrongful conduct. But as you might expect, the discharge the case was settled. There is a Ninth Circuit case on point, though, that it doesn't violate the First Amendment for a public employee to be fired for membership in that type of organization. Fitness is very often raised when an employee is terminated for off-duty misconduct which is viewed as conduct unbecoming to the agency for which the employee works. That involves drug, sex, and rock and roll in every type of permutation. Employers may also cite immorality or violations to public trust. If an employee is incarcerated because of criminal off-duty conduct, they are unavailable to work. That may be a basis for which the employee cannot show up and may be fired. But even in these cases, the facts have to be raised by the employer. It's the employer's burden of proving that the employee is unfit based on their off-duty behavior, and that can be quite a significant burden. It's not enough that the behavior is distasteful or wrongful. The employer has to show by some level of objective fact a connection to work duties. Again, I've referenced a few times the special role model responsibilities for folks in the public sector. In some ways, I think that the deference given to free speech by virtue of state and federal constitutions, especially here in Oregon, we have a quite robust state constitutional law tradition, which protects the actions of individuals and limits the power of the state to act with respect to people's First Amendment type free speech activities. Still, those same sorts of questions can arise, situations that I'll get into later with respect to the specifics. The reason why we call this presentation Sex, Drugs, and Rock and Roll is that, at least in my experience, most of off-duty conduct cases involve one of those three areas. And I'll just give you an example of how significantly the type of cases change, but the category remains the same. For example, in the sex cases, in the old days, it used to be that an employee would be terminated for off-duty LGBTQ or homosexual activities. Now, I think it would be unusual for an employee to be terminated based solely on off-duty consensual sexual activities with another adult, even if it's an LGBTQ situation. But we still have cases that turn on off-duty connections to a person's sexuality. We may have cases related, for example, to people who are transgender. Can a person who is undergoing sex confirmation surgeries, going through a name change, is it appropriate, even though those are off-duty in some sense behaviors? Can a school district, for example, terminate a teacher who is going through that process because they feel that students might be harmed by being exposed to a transgender person? That's the type of question that can come up. In progressive states like Oregon, we have protections against discrimination based on LGBTQ status, so the case is answered by virtue of statute in both the public and private sector, but there are states where this is not the case and where federal law may prove to no longer protect transgender employees. So again, I think there'll always be off-duty sex cases that will provide us good fodder for these types of presentations in the future. Sex cases, we also have employees on their breaks and off-duty time at work or unassigned time at work engaging in sexual conduct. I've had, many cases where employees have engaged in consensual affairs in locked rooms during their time off because it was a place that they could go with the hope of non-discovery. Certainly, those cases really pose a question as to the power of the employer to regulate what would normally be considered private behavior by adults. Sexual harassment is also the type of sex case that can involve both a mix of on-duty and off-duty behaviors, and can be very difficult to unravel. Again, if the person that contends that there is sexual harassment is involved, they're going to have to prove the same elements as in any other sexual harassment cases. But the context of off-duty can complicate the case significantly. Drug cases, again, another really prime category of off-duty misconduct cases. Again, the duty is on the employer to show that any off-duty drug use actually impacts the employee's ability to do their job with respect to fitness, or has some way caused harm to the employer's business. The mere fact of being a drug user, legal or illegal, is not enough standing alone to prove the nexus to employment. Obviously, there are cases that have to do with drug testing. I'm not talking about drug testing cases because those are generally at the employer's bequest. And often there are very complex drug and alcohol policies in which unions have bargained for the quid pro quo of drug testing. Mandatory drug testing is the opportunity for the employee to attend treatment. So I'm not going into that. There can be a question, though, of whether an employee who goes into rehab and is unable to attend work, whether the employer, they find out about the status of the employee, whether they have the ability to take action. We, of course, have state and federal laws on the rights of employees to use time off for these type of medical concerns, the Family Medical Leave Act and so on. But it still can become a question where rumors are generated about an employee's drug use, which can impair the reputation of the employer and of the employee. So it can be a complex issue that an arbitrator will have to unfurl as they look into the facts of these cases. These cases are extremely fact-driven. One or two changes in fact can change the outcome. Sometimes an employee will admit to off-duty drug use, or there will be police involvement. And it's very interesting how to develop a nexus. We had a case where a teacher's husband was involved in a grow operation in they lived on a large piece of property. The grow was off very far away from the house where the teacher lived. The police came and raided the operation, and the teacher, who was not involved in the drug grow operation, was herself fired. And then the question became, what is the connection between the teacher and her work? The school district asserted that the teacher, by allowing a grow operation on her property, had condoned the use of drugs, had somehow placed her, that she was supporting this use, and it became a very factually intensive case. In the end, the case was decided based on the question of whether there was a duty. What was the duty on the part of the teacher in that circumstance with respect to a married woman with children who really didn't have control over her husband's actions? She was eventually reinstated. So the rock and roll cases, we're going to have a special presentation on social media. I often enjoy looking at what happens. We have cases of cyberbullying where one employee completely off duty is accused of texting or using social media to attempt to harass other employees. The questions can arise with respect to proof and with respect to the employer's right to access a private phone. These are cases that you can expect to find, and the same tests will really be involved. In other words, even if something is off-duty, if the impact of the off-duty behavior is to make employees unable to work together, we know that that can happen, certainly in this type of circumstance. So the employer may be able to engage in disciplinary action of an employee found guilty of cyberbullying a coworker simply by virtue of the impact of the conduct in the workplace. The question, I wrote this line on the slide, divorce and the spouse who calls the employer, because I have had a number of cases where when people are having some sort of domestic dispute, where the unhappy spouse will call the employer without thinking very far down the line about the impacts and reveal, for example, that the employee routinely drinks at work or smokes marijuana off duty. They're engaged in a custody battle, and perhaps they're hoping that the employer will take some action that will benefit this spouse in this proceeding. But what I'll say to that is that oftentimes if a true off-duty situation arises where the employer will take action, that might happen. But in the cases I've handled, oftentimes the source of the information is so not credible that very little has happened with respect to these sorts of complaints. Now, what factors do arbitrators think are important in considering off-duty conduct and determining whether there is a nexus? As I said, it's quite factually dependent. Every case is different. And one fact can change the outcome. But one thing that to be careful of, especially from the union side, is to pay attention to whether the employee used any instrumentality provided by the employer. Did the employee use the employer's phone, computer? Did they access addresses through an employer database? Did they in some way put their hands in the employer's cookie jar so that they are now, they have created the nexus by using an employer's possession? Some off-duty sex, drugs, and rock and roll happen when employees go to conferences out of state, sometimes with other employees from their same workplace. Is it a nexus created simply by the fact that the employer has sent two coworkers to a conference, paid for their hotel rooms? If something happens of misconduct in that situation, does the fact that the employer has paid for these accommodations mean that the employee, anything the employee does will have a nexus to their employment? Questions like this, again, can show the wide factual variety of cases that arbitrators face. But certainly, if you have a connection through use of employers' possessions or access to a person by virtue of their employment or use of work time, those sort of factors create the nexus. There's also cases, I've had cases of employees they're driving home from their workplace and they're wearing an employer uniform, or they're off duty and they're wearing a union shirt that discloses their employer. If the employee engages in an incident of inappropriate driving and are stopped by the police, does the fact that the employee has worn a uniform or has done something that places them as an employee of this particular employer, is that enough of a nexus? And I've had arbitrators say, yes, it is. If you commit a speeding violation while in your police officer sweatshirt, you have placed your employment status at issue for virtue of the driving misconduct you may have committed. But again, these are cases that can go either way depending upon the particular facts. Now, another very important factor that arbitrators find important are very traditional just cause considerations that can be applied in almost any case. And arbitrators don't like to make up their law from scratch. Even though they're creating the law of the shop, oftentimes what arbitrators will do is take an existing test or an existing body of law and apply it to a new body of law. And that's what I believe has happened with respect to the drug, sex, and rock and roll off-duty misconduct cases. The arbitrator is going to want to know whether the employee knew that this type of misconduct could get them into trouble. Is there a policy that specifically tells employees that their off-duty conduct is part of the expectation of the employer, that their off-duty conduct will be lawful or in some other way a role model? Many employers have adopted these policies since arbitrators began invalidating discharges because there were no such policies. Now, almost every time I always look for this sort of link, and typically there is one, but especially in the private sector, I would look very carefully for a policy that specifically says that off-duty conduct can affect employment. Because arbitrators always want to know whether an employee knew or should have known that their conduct could result in discipline. And the lack of a policy can be a significant piece of evidence that might persuade an arbitrator that it's not fair to terminate an employee for off-duty conduct when they didn't know that was a possibility. In general, arbitrators like employees to be given the opportunity to comport with the employer's expectations, and if there are no notice, then the employee is unable to do so. Again, non-discrimination is an important principle, and reasonableness. I think that these days we're entering into a new situation with COVID. Now we have 34% of workers working from home. What does that mean with respect to off-duty misconduct? Well, now I have my office, my home office is in the background. I don't think there's anything that would offend anyone. Possibly my certificate of graduating from NYU Law School might offend somebody who went to Columbia. But what about the person who puts a Blue Lives Matter flag in the background of their Zoom background or has it in their home? You know, what if there can be many images that an employee can have on a calendar that shows up in their Zoom call, or other cultural representations that are viewed as offensive. These are what I view as areas for the future. And I think that the arbitrators are going to look at using similar standards to those that they have used in the past with respect to other off-duty questions. It's going to be an issue whether, when you're on a Zoom call, what you have in the walls of your home is subject to regulation by the employer. And it will be a very fact-specific inquiry. And that's one thing I can really assure you of. So good luck as you handle these cases in the future. I hope this review of Nexus rules is helpful.
My name is Catherine Walters, and I am going to speak with you today about medical and recreational marijuana in the workplace. We're seeing such a flurry of new state laws. Grass is getting the green light all over the country. We're seeing lots of medicinal marijuana laws that are protecting individuals who need to use medical marijuana. We're seeing a move towards decriminalization of marijuana laws. And of course, we're seeing states that have legalized recreational and medicinal marijuana. Of course, let's remember that under the law, under federal law, marijuana remains a fully illegal Schedule I drug. And so, of course, that creates a lot of different issues with respect to co-enforcement or preemption. For today's discussion, I'm going to speak more with you about the different types of laws in the various states, and then how those laws impact employment policies, and then how employers will interact with employees, unions, and hopefully not end up in arbitrations. So as you can see on my slide, at my writing, at least 11 states, including at least 11 states plus the District of Columbia and Guam, have fully legalized medical and recreational marijuana. You can see that 33 and more states, because to me there's a question as to whether medical marijuana is the same thing as CBD legalization, but more than 33 states plus Puerto Rico have medical marijuana programs implemented. Some of those states, however, only permit CBD oil. They don't permit other forms of medical marijuana. And then we're seeing, as I said, a move towards the decriminalization of marijuana, regardless of whether recreational marijuana or even medical marijuana has been legalized in those states. And then, of course, we have 6 states where marijuana remains fully illegal. Interestingly, medical marijuana, when it was first implemented in the leading states, think Colorado, think California, they saw their state budgets rise tremendously. The states became sort of the epicenters of people attempting to access marijuana, and a lot of the other states fell in behind it. So when we ask who benefits, not only do medical marijuana users or people who need medical marijuana benefit, but the states who implement medical marijuana programs. And I'm using Pennsylvania as an example. Of course, I'm in Pennsylvania, but Pennsylvania is right in line. We're kind of in the middle of things. We have medical marijuana here, and we are looking very, very closely at legalizing recreational marijuana. However, as I said earlier, recreational marijuana has gained quite a bit of ground. 11 states now, DC and Guam. And then many other states are moving towards legalization, and if not legalization of recreational marijuana, at least decriminalization. Several states are going to be going online with legalized marijuana in 2020. Now, when we look at state marijuana laws, we look at quite a potpourri of different types of provisions. Some of these laws have been drafted very, very carefully and very focused on their impact, not only on the individuals who will benefit from the use of medical marijuana per se, but also on how marijuana is accessed, how it's produced, how it's sold, and how it's distributed. So typically, the state marijuana laws are going to have provisions that cover these numerous bullet points in my slide. The most important aspects, though, of course, relate to, for employers, certainly relate to the list of serious medical conditions for which medical marijuana may be used, because those do change from state to state. Some states have very broad definitions of a serious medical condition. Other states list them out very specifically, are willing to add them as their various task forces determine that they're appropriate to add, and so forth. For example, in Pennsylvania, we've added multiple serious conditions since the Pennsylvania Medical Marijuana Act was put in place. Other aspects are the forms of acceptable and unacceptable marijuana. For example, in Pennsylvania, we have multiple forms that are permitted, but smoking and edibles are not permitted in Pennsylvania. However, we do see the dry leaf and flower for vaporization and nebulization, the liquids, oils, pills, and tinctures, and so forth. Other states do provide for edibles and smoking, and a number of people are known to drive to those kind of bordering states, to Pennsylvania, to pick up edibles and bring them back. But those, of course, are crimes in themselves. In any event, these are just an array of types of provisions that these laws do contain. And wherever you have employees or wherever you represent employees, you must be mindful that the laws in each state differ from state to state, and then we have numerous localities with laws as well. So, just a little bit of levity here. We all know what joint employment is under the wage and hour laws, but this one I couldn't resist. Now, when we talk about what an employer is supposed to do with respect to these myriad changing marijuana laws, we really focus on how do we keep a safe and productive workplace. Those of you who practice in the area of OSHA know that under the General Duty Clause, employers have a duty to provide a safe workplace for their employees. And certainly OSHA does permit drug testing. Drug testing, of course, I think is one of the most difficult and important aspects of an employer policy. Remember that drug testing is not truly a reliable indicator of what it seeks to prevent, and that is impairment on the job. When we are looking at marijuana, whether it's medical marijuana or recreational marijuana, drug testing doesn't necessarily demonstrate that someone is impaired. It just demonstrates that someone may have engaged or imbibed or otherwise used marijuana within a certain period of time. Marijuana and its various properties stay within a blood system for a very long time. For example, an individual might have gone to Canada, had an edible, maybe smoked some pot, came back. A couple days later, they come to work and they take a drug test, and the THC is showing up in their system, but that does not mean that they are currently intoxicated or otherwise impaired. So employers have had to engage in a lot of soul searching with respect to what they want to do with their drug testing. While, of course, they remain free to implement drug testing programs, they have to take into account, again, the changing laws from state to state, as well as what the testing is going to prove for them. Remember, marijuana remains illegal under federal law because it does not currently have a federally recognized medical use. And so when the states do provide for medical marijuana laws, they're saying that we recognize a medical use. And since state laws vary, we focus then on how do they vary and what do they prevent or permit the employer to do. Now we're seeing a number of things that have to do with pre-employment testing, and I'll address that on the next slide. But for the most part, we're really focusing on employers having a better sense of how the drug testing panels that they're doing work, what those panels actually describe, and whether they even wish to continue testing for marijuana, particularly in a state where both recreational and medical marijuana is permitted. On this slide, I've provided a number of concepts that should be considered when an employer goes forward with a drug testing program, particularly that it must be job-related and consistent with business necessity. Another aspect of all of this, though, is that the drug testing program should be very, very clear about when drug testing will occur, how it will occur, and what the outcomes will mean and what the outcomes will result in for an employee, along with the concept that the failure or refusal to take a drug test when warranted or requested could indeed result in termination. Some other drug testing peccadillos, however, relate to the FedDots. Regardless of state law, the Federal Department of Transportation, which applies to over 8 million workers in the United States, requires substance testing for commercial drivers. So an employer needs to assess what jobs it actually needs to make testing apply to, and a lot of employers are focusing on only testing safety-sensitive or other types of jobs where impairment or intoxication could have devastating effects, as opposed to testing every employee, including administrative staff and so forth. We're seeing pre-employment testing coming under fire with these varying state and local laws. Currently, pre-employment testing is prohibited in Nevada and New York City, with various exceptions for safety-sensitive jobs and other very specific exceptions. And the other aspect of pre-employment testing is that applicants who are eligible for medical marijuana often will test positive for marijuana or cannabis or THC, and we have to now avoid our knee-jerk reactions of refusing to hire people who test positive. We need to now focus on whether there's a reason for that test and whether the individual is eligible for medical marijuana, and then focus on whether we can accommodate that, that deviation from our typical, perhaps a zero tolerance testing. Remember, too, that CBD products may be permissible, but they also can have THC in them. Typically, CBD products are not highly regulated, and so they do get contaminated, and ultimately they can cause a lot of false positive tests because they are either contaminated by THC or they contain more THC than was anticipated. Oral fluid testing is gaining ground as well. We saw recent issuance of the new guidelines by the U.S. Department of Health and Human Services. Those guidelines were issued last fall, and they became effective on January 1st of 2020. There's a reason why oral fluid testing is gaining ground. It is quicker, it is cheaper, and it is more user-friendly, let's say. So, for example, urine testing, often poses obstacles, mainly because there has to be an appropriate place for the individual to provide their sample. There are a lot of products on the market that can adulterate samples. Oral fluid collection does not require secured restrooms or other special requirements that urine testing might require. Oral fluid collection is conducted under direct observation rather than non-direct observation, which would also substantially lessen the risk of substitution or adulteration. And of course, it saves time when compared to urine testing, and it turns out that it's a little bit less expensive. So we're seeing a lot of employers moving towards oral fluid testing, while the HHS guidelines are now relevant really to federal agencies. A lot of private employers have been using them for quite some time, and with the more specific guidelines that have been published, we'll see more employers moving in that direction as well. Now, as I indicated, OSHA requires the employer to provide a safe workplace, and it does not prohibit drug testing. We also have a number of federal contractors who are bound by the Drug-Free Workplace Act of 1988. And remember, these are federal contractors who provide services but not supplies. And on this slide, we see that federal contractor employers must implement the policy that prohibits use or possession in the workplace, and they must report drug-related crimes that occur in the workplace. Most of the state laws and the Americans with Disabilities Act provide that employers may meet their respective federal and state requirements. So they do give a little nod to federal and state contractors. And it does not require, the Drug-Free Workplace Act does not require drug testing. It permits it, but it does not require it. So that is a bit of a fallacy. A lot of employers do hide behind the Drug-Free Workplace Act of 1988 to avoid or attempt to avoid some of their obligations with respect to marijuana. But for the most part, you have to have that implemented correctly and understand the various aspects of it in order to actually use that law appropriately. However, it is very important that a contractor abide by the Drug-Free Workplace Act, and many of their ultimate testing decisions should be done in conformance with the laws of their states. And they should be very much aware of what their particular jurisdictions permit or provide for with respect to preemption of federal law. Now, let's talk a little bit about the Americans with Disabilities Act. And as you can see on this slide, individuals who currently engage in the illegal use of drugs are not protected under the ADA. However, we need to take into account that the underlying condition for which the individual is using medical marijuana may indeed be a disability. And recall, too, that under the ADA, the illegal use of drugs does not mean the use of a Schedule I drug that is taken under supervision of a licensed healthcare professional. So even Schedule I drugs are permissible under the ADA so long as they are taken under supervision. The primary goal really for employers would be to ensure that employees are not engaged in the illegal use of drugs. Some other concepts about the ADA are here on this slide. And I think the top several bullet points are the most important. Under no circumstances, whether it's recreational or medical marijuana, is an employer required to permit ingestion at work or to permit an individual to be under the influence, impaired, or otherwise intoxicated at work. Yet the employer does need to engage in the interactive process to determine how they can work with that employee, even if it is to find a way to allow them to use their medical marijuana, whether it's before work or after work, or how to read a drug test where that marijuana might show up. With respect to the Family and Medical Leave Act, again, the use of medical marijuana is not currently a serious health condition under the FMLA, but again, it may be required to provide leave in order to accommodate the medical use of marijuana due to a serious health condition. And of course, if an employee chooses to seek substance abuse assistance, they would be eligible for an FMLA leave to do that. Now, of course, we are dealing with a pandemic. And I like pot and the pandemic. One of the things that has cropped up is the concept of remote workers. More people are working remotely. And of course, we talk about pandemic stress-induced drug use and the concept that people are using medical marijuana or recreational marijuana at home where they happen to be working. Employers still have the right to prohibit the use of drugs or illegal drugs at and during work, and they have no requirement to accommodate workplace or work time use. The question really becomes how to enforce this in an employee's home if that's where they're remote working from. Really, the best practices that you can implement with respect to this would be simply to remind remote employees of the employer's policies and expectations, remind them of the drug policies that you have, the anti-drug policies, drug testing policies, and remind them too of any conduct or performance expectations, because these expectations are going to remain in place regardless of where an employee is working. One of the ways that employers are encouraging remote employees to not use recreational and medicinal marijuana during working hours is to simply encourage them to maintain their regular routines and their regular work hours, even though they're working from home. Some employers have gone so far as to indicate that they must perform their work during certain hours as though they were at the office, and that work before or after those hours is not appropriate. We won't get into any wage and hour law issues here, but in essence, if you can get your employees to retain their regular routines, then perhaps they won't feel slighted. Another approach is to stay in regular contact. Use Zoom and video conferencing. That way you can actually see the employees. They're going to be a little bit concerned about being seen. And if someone is impaired and acting impaired, you'll actually be able to see them doing that. And if you decide that you want to send them for a drug test, which is not really advisable at this time, you can certainly do that, knowing, of course, that we're dealing with a pandemic and that a drug test may not be high on the radar standard at this time. But again, I think it's appropriate certainly to remind people of their policies and procedures. My perspective is we should always focus on productivity rather than policing of employee behaviors. My final slide really deals with some takeaways, and I think it's pretty obvious for employers. We really want to see clearly communicated policies and expectations. The primary goal should be safety and prevention of danger and illness and accidents in the workplace. And of course, another primary goal is productivity. For unions, we always expect cooperation with the employer, but also strong communication about issues, about the policies, requests for assistance between the union and the employer, prevention and safety of workers, while at the same time protecting their rights. And of course, our arbitrators always understand that we need to protect employee rights, but it has to be within evidence, under contract, and within the law. And with that, I will step back and allow others to make their presentations. Thank you very much.
My name is David Stiteler, and I'm going to talk to you today about the workplace challenges that can be caused by social media use. I'll preface my remarks by letting you know that I'm an arbitrator of labor relations disputes. So my perspective on this may be a little more limited than an arbitrator who would deal with employment disputes. And my perspective also might be different than that of employers, who are the ones who most often have to deal with this. I should point out that this is a very, very brief introduction to this topic. I think this is the 5th time I've made a presentation on social media use in the workplace or related topics, and it's not uncommon for these to be 2-hour or half-day programs. Contrary to the cartoon that you see on the right here, I'm not going to be addressing pre-hire social media use, though that is clearly becoming and has been becoming over the last few years an increasingly challenging issue for employers. Finally, this is really, even though unions obviously have an interest here in protecting the rights of their members, this is really an issue for employers rather than anyone else. So the first question is, why is social media use a workplace challenge? Why should this be a factor? I've listed a few topics here which I'm going to address, and this is by no means an exhaustive list. The first is the growth of social media. We're talking about, I think the first presentation that I did on this topic was back in 2011. And to use Facebook as an example, in 2011, it had 800 million users, and that had been a growth over its preceding 7 years of 800 million. In 2004, it was nothing. And now, 9 years on, it's almost 2.5 billion users. And it's not only that there are more people using Facebook, there are also a lot more places for people to use social media. So I've listed the top 10 social media platforms, and Facebook is clearly the biggest fish in the pond, but it's by no means the only fish. There are over 200 social media platforms available, and there are 3.5 billion people who use social media every day. Another factor is the nature of social media. It tends to blur the line between on and off duty conduct and statements, and especially in the light of the post-COVID world that we're in right now, that line has already gotten pretty blurry. It also offers distance between a user and their statements or actions. So somebody who might be very uncomfortable saying a certain thing in a face-to-face confrontation with somebody may feel much more freedom to say that on social media. For some people, it provides a measure of validation. They look for an audience that thinks similar to them, and they're expecting and hoping for positive feedback and reinforcement, so to validate their beliefs. For certain users, it provides either in the alternative, either anonymity or notoriety, depending on what they want. Magnified consequences, I think obviously the events of the last week, even though this did not arise strictly speaking in a workplace context, the events of the last week and the killing of George Taylor demonstrate all too well how the consequences of social media can magnify things in a hurry. There's certainly no doubt that his death, Floyd's death, would have led to widespread protests, but there's also no doubt that the fact that it was filmed and that film went viral magnified those consequences to the point we are at today, that these protests are going on worldwide. So before, where an employee's statements or conduct might have remained under the radar, now it's much more likely that those things will become a public issue, and that can lead to conflict at work. It can lead to interference with the employee's ability to do their job. Before, there was often not a direct connection to the employer. That is now there is more likely to be a connection to the employer, which can put the public eye on the employer in a way that is not favorable, damaging the employer's reputation, damaging the employer's relations with its customers. Generational divide is less of a factor than it was 10 years ago, as boomers are aging out of the workplace. But you can see there's a really big difference in the amount of use, and that tends to lead to a big difference in their perceptions and acceptance of social media. Only about half of boomers use social media regularly, over 90% of millennials. On duty use, there are two main areas of concern. One has to do with use, or I should say misuse, of work time, and possibly misuse of the employer's equipment. So most employers have policies that can address those things. Most employers have general policies of conduct that prohibit an employee from using company equipment for their own purposes, prohibit employees from wasting work time. The other area, though, is a little more complicated because that's where you get into the blur between on and off duty. Very often an employee's social media use doesn't really have anything to do with work, even though they may be doing it during their work day. So you get there into the content, and those present a little more problematic areas for the employer to deal with. When you talk about off-duty use or misuse of social media, there are two general areas that are going to come into play. First is employee-generated content. Second is third-party generated content. Employee-generated content are those kinds of posts or statements or actions that could be considered harassment or discrimination. There may be negative statements about the employer. Employee may be disclosing trade secrets. The employee may be saying something that's not directly work-related, but because of a tie between the employee and the company or the employer, nonetheless reflects negatively on that employer or causes conflict at work. A couple of cases to consider. On the right side, you see these are things that have just been up in the news over the last 6 months or so, maybe a little longer than that, but where public employers, in the top case, the Customs and Border Patrol agency had to deal with Border Patrol agents who were posting racist and offensive content on a private Facebook page. And Hampton College, which is a private college, ended up having to fire 9 police officers for their posts on social media. The case on the left-hand side of the slide, you've got a city employee who is a member of a club that collected World War II memorabilia. The guy found an old Nazi uniform, put it on, took a selfie, posted it on his Facebook page. Some other people at work were members of the same club. The picture circulated around the office, and an employee was not a member of the club but had lost relatives in Nazi concentration camps, was upset, went to complain to the city council. City council felt that they had to take action. One of the issues that could come up in that kind of a case is whether or not, there's no suggestion that the guy who took the picture had any Nazi beliefs, but you have to wonder about motivation and whether or not the employer's reach in this case goes too far. By far the more difficult category of cases, in my view, are those dealing with third-party generated content, where somebody else takes a video or a picture or makes a post or tweet about an employee or the employee's conduct or statements. A couple of cases here for you to consider. One on the left, photo op. This was one of the very, very early cases about online postings and its workplace consequences. This teacher attended a really, really notorious outdoor party. There was a lot of drinking involved. Some of that drinking is pretty risque. While this teacher was taking a drink, somebody without her permission or consent took her picture, posted it online. it came to the attention of a parent at the school who took it to the school board, and the school board took action. The other case involved a bus driver who didn't make any posts personally about his off-the-job activities, which included being head of the local KKK, but other people made posts that became a news item, and that led to a boycott of the bus company, which led to the boycott taking action. In more recent news, at a protest, this relates back to the George Floyd issue, at a protest in New Jersey just the other day, protesters were marching against police violence, and off to the side of the protest along their march route, there was a group of people standing in front of a Trump banner, and as the protesters came alongside them, they reenacted the killing. And somebody was upset by that, took a video, posted it online. It turns out that one of the people involved in the reenactment was a New Jersey corrections officer, and another was a FedEx truck driver. And when the New Jersey Department of Corrections found out about the video, they suspended their corrections officer. When FedEx found out about their truck driver, they fired him and issued the statement that FedEx holds its team members to a high standard of personal conduct, and we do not tolerate the kind of appalling and offensive behavior depicted in the video. Even more recently, just this morning, I read in the paper that the CEO of the CrossFit gyms was forced to retire after he had made insensitive or offensive tweets about Floyd's death, and then followed that up on a Zoom call to his associates by saying, "I'm not mourning Floyd's death, and I don't think any of my staff are either." When these cases come to arbitration, they're generally coming to arbitration as discipline matters. When we're talking about, even though this is social media's relatively new, it really took off beginning about 2012 when smartphones really took off, and everybody's got a little computer in their pocket and they can engage with social media anytime they have the whim to do so. But for arbitrators, even though it's a relatively new arena, basically the same analytical formulas are going to apply. If it's off-duty conduct, the employer's going to have to establish nexus. The employer's also going to have to establish that they had just cause for whatever discipline was imposed. And that means, did they show that there was misconduct? Did they give the employee the appropriate due process? And was the discipline appropriate considering? Other issues that can come up deal with privacy rights, evidence, like should these social media posts have been admitted into evidence, whether there are legal issues, for example, harassment or discrimination. There may be other legal or constitutional questions as well. My takeaways for employers, my number one takeaway for employers is that you need to have a specific policy addressing social media use. It's not enough to rely on general conduct policies or policies about use or abuse of time and equipment. Any policy that you write should specifically address what you prohibit disclosing, should specifically, or at least to the degree you can, address what conduct is going to be prohibited, specifically address what the consequences will be for violating the policy, and make damn sure that you give all employees training in this policy. To the degree you're going to try and reach into off-duty conduct, you want to make sure that you keep those elements of nexus in mind so that you're not overreaching, because one thing that will lead your policy not to be very well accepted in arbitration is overreaching. A couple of caveats for public sector employees, public sector employers. Public sector employees may have increased privacy rights, and their conduct may be constitutionally or statutorily protected in ways that private sector employees don't get. Takeaways for unions, even though this is mostly an employer issue, unions have a role in protecting their members' rights, specifically their privacy rights. Remember that you want to keep also the focus on just cause and nexus factors. To the degree you want to get proactive here, you want to educate your members about the risks and benefits of social media use and make sure they understand the potential for discipline if they go too far. And that's all I have for now. I understand that we're going to be available for questions at some point. Thank you for your attention.
That concludes our presentation. Barbara, Catherine, and David are now available for questions. Does anyone have any questions they'd like to ask? You might need to unmute yourself. Any takers? No? I'll wait another moment.
Well, I thought it was a very good presentation. Took a lot of notes, and will the PowerPoint that was used, will that be made available to us?
Yeah, I can post the PowerPoint presentations on the discussion thread.
Okay.
And it'll be available for you to access, as
All right,
well as the video.
All right, thank you.
Thank you. Anyone else with a question?
How about, I'll make this a question. It's not really right if we all give scenarios, but I was working with the union recently and had an interesting one where it's in healthcare. And so the discipline from the employer came as the healthcare worker was acting as a patient. And I don't know if any of our panelists have ever encountered something like that, but it really took me aback. I've worked with the healthcare union for many, many years, and basically it was around the conduct of this person clearly as a patient. They weren't on work time. It wasn't even the hospital that they were employed in, but another one in the enterprise. And I had just never heard of anything like that. It seemed to me, I mean, certainly I advised the person about looking at the nexus, but it was just quite concerning that someone could be a patient and then end up in discipline. So I suppose there might be HIPAA or other things to consider too, but just curious if anybody's ever experienced anything like that.
Well, I have not experienced that set of circumstances, but I think some of what you've just said makes me question the appropriateness of it. Obviously, there are a lot of facts involved, but it seems to me that if the person was not on work time, was acting as a patient, wasn't even in the place where he or she worked, we are dealing with HIPAA issues, and we are dealing with a number of other aspects of what is the nexus to the employment. So it seems to me that you are correct to question that one.
We have a question in the chat box. I think this is for Catherine or anyone. If drug testing is required for marijuana in a legal state, how often do you see workers' unions winning cases where impairment isn't an issue?
That would assume, I'm just going to assume from the question, and correct me if I'm wrong, you're talking about a situation where there's some sort of either not a for-cause drug test, but just a random drug test results in a person in a state where cannabis is legalized, that they're found to have a dirty test. Well, the big juncture is always going to be whether the person is subjected to the federal Department of Transportation regulations, which kind of preempt any local laws or not. So I'm not sure if I have the facts quite right here, but if in general, I know in Oregon, I've done some cases that involve, I remember I had a case where a teacher in the beautiful city in the Willamette Valley, Eugene, Oregon, you may have heard of it, the teacher was going through a divorce, and the disgruntled spouse, ex-spouse, called the school district during the summer and said, my partner smokes marijuana. And so the district invited the teacher to take a drug test, which they volunteered to do. And of course, once you consent to a drug test, you've waived any constitutional challenge, because a consensual test is going to be constitutional. And her drug test came out to in fact demonstrate that she did have marijuana THC metabolites in her system, but it was the summer. And what happened was the school district didn't know what to do, because they had conducted a drug test, found that a teacher was using it during their summer break, and actually they just did nothing, because and I have found that in many, having been here when drug testing started, the drug testing industry handed to management this technology that they could access, and then the drug testing industry has burgeoned. And but all during that same time, the culture around the use of cannabis has really evolved. So as what happened here, we had a dirty drug test, but the employer realized that it didn't really establish any reason to do anything whatsoever. So I don't know if that's a common result. I'll have to defer to my colleagues.
It seems to me where you have a drug test, regardless of what type it is, if you're finding THC in the blood in a legal state and impairment is not an issue, then the employer makes a decision at that point with respect to whether there is a reason to have further discussion with the employee. Again, impairment it's a relative term, and when you do the drug testing and you do the different panels, you have to assess at what level of THC are you going to actually take action. Again, it can be a reflection that the individual has used pot, whether it's medical or recreational, but that they are not currently impaired. So I think the second question there is whether there's impairment. And if there's no impairment, then again, the employer needs to focus on what kind of a state they're in and whether there's any reason to otherwise extend the question into the off-duty conduct. Was the person on call at the time they were using whatever they were using? Was the person otherwise potentially scheduled to come into work and shouldn't have been using? So I do think that there's no good yes or no answer to the second question. It's more going to be fact specific. And I would say, though, that where you're dealing with a non-impairment situation that was not, perhaps it was just a random test and the person hadn't engaged in any type of behavior, there was no reasonable cause testing and so forth, it is very likely that that individual should not face discipline. But again, it's going to matter from state to state and test to test and fact to fact. Thank you for that question.
It's also important to keep in mind the nature of, even in a legal state, who the employer is can make a difference, because Colorado is a legal state, but I had a case there recently in a federal prison, and federal employees, it's a whole different, it doesn't matter that Colorado is a legal state. If you're working for the federal government, you don't get to do drugs, marijuana or anything else. And that was a case that was similar factually to the one that Barbara mentioned, where the employee and his spouse were having marital difficulties, and the spouse reported the guy's drug use to the employer. So they did a little test, and of course he came up positive, and of course he lost his job. So the nature of the employer is just as important as the nature of the state.
Well, I just got a note that we need to clear the room for the next presentation. So I want to thank everyone for attending, and I especially want to thank Barbara, Catherine, and David for an excellent presentation. Thank you, everyone.
Thank you.
Hi, Hannah. All right. Whew.
Hi.
Thanks for bringing it to our attention. We were finishing up a committee meeting,
Oh, huh.
and when your call came in, I stepped out of the committee meeting to answer.
Well, I appreciate that. Thank you so much for doing that.
No, I'm glad you did, because I mean we were finishing up at 3 in there for this next session, but yeah, I think they would have kept going. So I had to give them the hook. Okay, so Hannah, you need co-host. Does anyone else need co-host with you, Hannah?
Lisa.
Or Lisa, do you want? Okay, perfect. All right. If you need anything, let me know. You'll probably see my picture, or it's not my picture, it's me, just kind of scanning along the screen as I check on you, though. Okay.
Okay.
Oh, did you start the recording, or did they not stop theirs?
They might not have stopped there. So